Ohio Laws Administrative Rules, Division 50, Chapter 1509, Division Oil, Gas Resource Management, Oil and Gas. Starting at 1509:31. Operation Well Notice to hold a royalty interest assignment transfer entire interest and lease. No person shall operate a well in the state unless the person first registered with the retained with identification number, the chief of the Division of Oil and Gas Resource Management. Whenever the interest of the oil and gas lease is assigned, otherwise transfer the assignment of the transfer shall notify the holders of the royalty interest if the well exists with the lease of the Division of Oil and Gas Resource Management over the name and address of the assigner of the transferee by the certified mail with the return receipt no later than 30 days after the assignment or transfer when the notice of any such assignment of the transfer is required to provide with the Division and shall provide with the form prescribed provided by the Division verified by both the assigned transferor or the assignee with the transferee with the notice applicable to assignment transfer well with the owner surface estate with the track of which well was located shall contain the statement informing the landowner that the well may require periodic servicing to maintain productivity upon assignment or transfer of the well. If the landowner becomes responsible for the compliance requirements of the chapter rules adopted under it, included without limitation, proper disposal of the brine obtained with the well, with the plugging of the well becomes incapable of producing oil or gas, and restoration of the well site. Upon assignment with the transfer of the well, the landowner becomes responsible for the cost of the compliance requirements for the chapter rules adopted under it and cost operating services as well. Notwithstanding Division A2 of the section and assignment transfer shall know of the Division Oil Gas Resource Management assignment transfer of both the following apply. The assignment transferee failed to notify the Division assignment of the transfer required by the Division A2 of the section assignment transfer of the deceased dissolved cannot be located otherwise incapable of complying with the notification requirements. The assignment transferee shall notify the Division assignment of the transfer or the transfer on the form prescribed or provided by the Division. A minimum of the form shall be required assignee with the transferee to attest. The assignee with the transfer is the owner of the Division shall not charge a fee for such assignment of the transfer with a notice provided in accordance with the Division A3 of this section when the entire interest of the well is proposed to the assigned otherwise transferred to the landowner except for the domestic well owner who has been issued with a permit under the chapter of the well submitted with the chief of the Division of Oil Gas Resource Management application for assignment or transfer will contain all of the documents the chief requires application such assignment or transfer shall be described provided by the chief may approve of the application accompanied by the release of all of the oil and gas leases included with the applicable with the formation of drilling unit release in form such as the well ownership merger of the fee simple interest to serve the track of the release and a form that may be recorded. However, the owner of the well does not release the oil gas lease associated with the well proposed to be assigned. Otherwise, transfer of the fee is simply track with the result of the merger well ownership simple interest surface track less than 5 acres proposed except for the domestic well owner shall put $5,000 bond with the Division prior to the assignment of the transfer of the well to ensure that the well will be properly plugged. The chief for a good cause may modify the requirement section governing assignment or transfer over the interest of the well to the owner. Upon assignment over the transfer of the well, the owner except the domestic will not subject to the servant tax levied under sections 574902 of the revised code. Subject to all applicable fees established in this chapter. The owner holding a permit under section 150905 of the revised code is responsible for all the obligation liabilities imposed in the chapter of the rules of order term conditions. Permit adopted issued under no assignment to transfer the owner relieves the owner's obligation liabilities unless the assigner transfer file of the Division information described in Divisions A1, 2, 3, 4, 5, 10, 11, and 12 of Section 150906 of the Revised Code obtains liability insurance coverage required in Section 150907 of the Revised Code, except when none is required by the section, executes a file security bond. Negotiable certificate of the deposits or irrevocable letters of credit and cash for the described in section 7 of the bond only upon the issue and acceptance of the chief assigned transferee may file with the proof of financial responsibility described in 150907 of the revised code section 150907 1. Revised code apply with the surety bond with the cash negotiable certificate of deposit with the revocable credit described in this section unless the chief approves modification. Each assigning transfer shall operate in accordance with the plan's information filed with the permit holder under section 150906 revised code. If a mortgage property that is being foreclosed is the subject of the oil and gas lease pipeline agreement, other instrument related to production or sale of the natural gas lease agreement, or the other instrument recorded subsequent to the mortgage lease agreement, and the other instrument is not with the default oil and gas lease pipeline agreement, other instrument applicable that has the priority over all liens, claims, and encumbrances on the property, so that the oil and gas pipeline agreement and other instruments are not terminated, extinguished upon foreclosure of the mortgage property. If the owned mortgage property was entitled to the oil and gas royalties before foreclosure, sale of the oil and gas royalties shall be paid with the purchaser of the foreclosed property. Alright, 1509-32 complaint alleging failure to restore disturbed land source or surfaces. Any person affected may file with the Chief of the Division of Oil and Gas Resource Management written complaint alleging failure to restore the distributed land surfaces with violation 1509-0702, 1509-22 with the rule adopted hereunder. Upon receipt of the complaint, the Chief shall cause the investigation to be made with the land's alleged violation has occurred, send copies of the investigation report with the person who filed with the complaint with the owner. Upon finding the violation, Chief shall order the eliminate the violation with a specified time if the owner fails to eliminate the violation time specified with the Chief may request prosecuting attorney of the county which violation occurred with the attorney general to bring appropriate action and secure compliance with those sections. Chief fails to bring with the appropriate action and secure the compliance with those sections within 20 days of the time specified with the person filing the complaint may request a prosecuting attorney of the county in which the violation occurred to bring appropriate action to ensure compliance with those sections of the Division of Oil and Gas Resource Management may cooperate any state local agency to provide technical advice or minimum standards for restoration of various soils and land surfaces or to assist in any investigation. 1509-33 civil penalties. Whoever violates 1509-01 and 1509-31 revised code rules adopted the order, terms, condition, permit, registration, certificate, issue, permit, these sections with no specific penalty which is provided in this section shall pay a civil penalty for no more than $10,000 for each offense which violates 1509-222-1 revised code. Any rules adopted under the term and condition permitted to issue thereunder with a civil penalty not more than $10,000 for each violation. Who violates D of section 1509-22 with the division A1 section 1509-22 with the revised code shall pay a civil penalty no less than $2,500, no more than $20,000 for each violation. Who violates Division A, Section 1509-22 of the revised code shall pay a civil penalty no less than $2,500, no more than $10,000 for each violation. Who violates Division A, Section 1509-22-3 revised code shall pay a civil penalty no more than $10,000 for each violation. F. Who violates 1509-072 any of the rules adopted, ordered, issued, administered, implement, enforce the section shall pay a civil penalty no more than $5,000 for each violation. G. With the addition of any other penalties provided in this chapter, whoever violates Section 1509-05, 1509-21 of Division B, of Section 1509-22 Division A, 1 of Section 1509-22-2 of the revised code of the term, condition, permanent of the order issued Chief of the Division of Oil, Gas, Resource Management under the chapter normally violates Division A, Section 1509-223 revised code is liable for the damage, injury caused by the violation for the actual cost rectifying the violation conditions caused by the violation if two or more persons knowingly violate one or more of the divisions in connection with the same event, activity, transaction, jointly, severally liably earn a division. H. The Attorney General, upon request of Chief of the Division of Oil, Gas, Resource Management, shall commence an action and section against any of the person who violates 1509-01 to 1509-31 of the revised code, any rules adopted, ordered, in terms and condition of the permit, registration, certificate issued pursuant to this section. Any action section is a civil action governed by the rules of civil procedures, other rules, practice, procedures applicable to civil actions. The remedy provided is division of cumulative and concurrent with any of the remedy provided within this chapter. The existing exercise remedy does not prevent exercise of any other except that no person shall subject to both civil penalty under Division A, B, C, or D of this section is in fine established in 1509-99 revised code, same offense. I. For the purpose of this section, each day violation constitutes a separate offense. Section 1509, priority liens by the Division of Oil, Gas, Resource Management, well owner failure of the pay fees for the costs incurred with the correct conditions causing health or safety risk. If the owner fails to pay the fees imposed within the shaft of the chief of the Division of Oil Gas Resource Management incurs the cost under the division as to the section 150907-1 revised code current conditions associated the owner will with the chief of the responsible determining causing imminent health and safety risk of the Division of Oil and Gas Resource Management has the priority to lien against owner's interest of the applicable well in front of all of the other creditors of the amount paid such unpaid fees of the costs incurred. Chief shall file a statement in the office of the county recorder in the county where the applicable well is located with the amount with the unpaid fees, costs, and incurred with the described in the division. The statement shall constitute a lien on which the owner interest as well as the date of the filing lien shall remain in for as long any portion remains unpaid until the chief issues certificate release of the lien. Chief issues certificate release of the lien. Chief shall file certificate release for the office of the applicable and county recorder. Lease imposed for the Division A1 section in addition with the lien imposed Attorney General for failure with the assessment imposed in Section 150950 of the revised code tax levied in Division A5 or 6, Sections 57 and 4902 revised code is applicable. If Attorney General cannot collect, sever, or honor an outstanding balance amounts due under the 150950 revised code of unpaid tax levied under Division A5 or 6, 57 and 4902 of the revised code applicable, the tax commissioner may request chief to impose property lien against owner interest applicable well such as lien property and on front of all the creditors. Chief property shall issue certificate release a lien under either following circumstances upon repayment full payment amount of unpaid fees imposed for the chapter of the cost of the incurred with the chief of the division of section F. Section 150907-1 of the revised code to correct conditions associated to owners and chief responsible has determined causing imminent health and safety risk. Any circumstance the chief determines to be best interest of the state, the chief may modify the amount of the lien under this section. Chief modifies lien sale file with a statement in the office of the county record with the applicable county of the new amount lien. D. Owner regarding the division recorded lien against the owner's interest as well according to the section shall not transfer a well lease or minimal rights to another person or owner until the chief issues certificate release of the lien against the owner's interest in them well. E. All money of the collection of liens under this section shall be deposited with the state treasury of the credit oil gas well fund created in section 150902 revised code. Alright, 150935 Oil Gas Commission. We're going to cut the tape there.